International Corporate Personhood, Business and the Bodiless in International Law by Kevin Crowe, published by Routledge in 2021. This book tracks the emergence of a distinct legal personality in international law, the International Corporate Person, or ICP, and asks how international law should respond to it. Crowe defines the ICP as a transborder legal personality to which an expanding arsenal of international legal rights exclusively belongs, and from which an expanding body of private normative rules flows. It is a person composed of persons, fluid in form and ownership, transcending states yet receiving form from states. It overlaps at times with the individual and at times with the state, yet accrues rights available to neither. 5 contemporary vignettes frame the stakes. In Urbes versus Argentina, a tribunal read a human right to water into Argentina's obligations, yet the corporation contracted to deliver that water bore no positive obligation to provide it. Exxon answered state investigations by asserting a political right to silence about climate change. Apple's Irish subsidiaries elected a profitable statelessness unavailable to any natural person. And Airbus purchased prosecutorial immunity through deferred prosecution agreements. The descriptive half of the book traces corporate personhood through 3 phases: the magistrate charter phase before 1850, the public charter phase from 1850 to 1945, and the personhood phase after 1945. A concept that began in U.S. domestic law was progressively animated internationally by courts, tribunals, and treaty regimes. Chapters 2 and 3 survey the ICP in judge-made and text-made international law, investment tribunals, the Alien Tort Statute, the European Court of Human Rights, the TRIPS Agreement, the OECD guidelines, anti-corruption instruments, and environmental texts. The analysis stresses that the ICP does not merely receive this law, it actively authors it. The descriptive section culminates in a list of 22 judge-made and text-made rights and privileges available to the ICP, but to no other international legal personality. These are later sorted into active rights, substantive rights the ICP can shape through its own agency, and passive rights, which are procedural. Existing theory places the corporation by analogy as para-individual, para-state, or para-institution. Crowe argues that all analogical approaches mischaracterize the ICP's unique status. The normative section instead adopts Philip Jessup's emphasis on human problems, urging pragmatic, solution-oriented reasoning in arbitral tribunals and international courts. The book's central prescription: international law should grant ICPS passive, procedural rights that answer genuinely universal problems, but should refuse to universalize active, substantive rights. And where ICPS have gained new rights, deferred prosecution, layered multi-jurisdictional taxation, inter-firm transfer pricing, direct liability, without the shield of the corporate veil, should follow under international law. The conclusion: beyond sovereignty, beyond the veil, diagnoses the status quo as corporate sovereignty as sword, and state sovereignty as shield. The more powerful the ICP, the more seamlessly it shifts between public and private to escape liability. Yet Crowe ends constructively: the ICP is the most flexible and adaptive of international legal personalities. If purpose and constituency can be redefined, it is finely suited and underutilized to realize radical change in environmental protection and cross-border wealth distribution. International Corporate Personhood, Business and the Bodiless in International Law. Kevin Crowe, Routledge, 2021.